Members, the question is that the motion be agreed to. Jacinda Ardern.
Mr Speaker, I want to start with at least some common ground, and I'm sure that every single member of this House would absolutely concede that we have a care and protection regime that can and must be improved. There are 5,000 young people in state care at any given time, and it's not only incumbent on us to do as much as we can to, in the first instance, ensure that those families and whānau are given the greatest opportunity possible to retain the key role that they have as primary caregivers, not the state, them, but in those instances where safety is a concern for a child, that the state improves the role that it then steps in to play, because there is no doubt that we have failed far too many on both the prevention and the intervention side. I think one of the more devastating reflections of that I have seen was the Children's Commissioner's State of Care report, where he blatantly stated that having looked at the state of care in New Zealand, he could not hand on heart confirm that children in care were better off than the situations that they were removed from. Now, that is an indictment in every respect. And so there is no denying that we can and should do better. But the debate that then arises is, what does that look like? How can we reform the legislation in a way that is, yes, child-centred, but recognises the important ties and bond with whānau, iwi and hapu, and the important need for cultural connectedness? And how do we improve practice on the ground? And it's something I've heard professionals talk about a lot. One thing that is absolutely unwavering is the desire amongst our social work professionals, be it within child, youth and family or out in the NGO sector, their unwavering desire to do the best they can by the communities that they work in. And it's something that I think we need to reflect more often in this debate. Our concern is, though, that this bill takes us backwards. That at one point, in fact, during the 1980s, after, and I'm taking this, in fact, from the MSD website, that during the 1980s there was increasing dissatisfaction with the negative effects statutory care practices were having on a growing number of children. That's according to Connolly of 2004. Children were frequently placed outside their kinship network, and the overrepresentation of Māori children in care meant that Māori families felt the effects of this cultural loss. Reiterating again, this is from the MSD website. In 1986, the most significant report to address welfare issues and the needs of Māori was introduced. Pea Te Atutu, Ministerial Committee, 1986. The report made many recommendations regarding the particular needs of Māori children and their families. Again, they are overrepresented in our SIFS numbers. But most critically, with respect to the care and safety of children, it reinforced the centrality of whānau and the maintenance of the child within the family group. The consequence of that report was that in 1989, we had groundbreaking legislation in the form of the Child, Youth and Family Act. It was groundbreaking, it was world-leading. It placed children and family at the centre of that legislation, but it also introduced practices like family group conferences. In particular, the principles of that Act under Clause 13 included sentiments like, for instance, that where a child or young person is removed from his or her family, whānau, hapu, iwi and family group, that wherever practicable, the child or young person should be returned to and protected from harm within that family, whānau, hapu and iwi. So of course, it puts safety first. That's never, ever been in question. Safety has always been first in that legislation of 1989. But it then went on to say that where the child or young person cannot be immediately returned and protected from harm within his or her family, that wherever practicable, the child should live, where appropriate, in the same locality in which the child or young person was living and in which the child or young persons linked with his or her family, whānau, hapu, iwi and family group are maintained and strengthened. The idea of these provisions were that there was priority, safety first, secondary to that, priority placed on the idea that children would be retained in kinship and whānau care. That might not be immediate family, it might be a layer outer, but either way it was recognising that that was of primary importance. This bill removes that provision. Now, I'm not just taking an interpretation of that. The Minister has been explicit that she has removed that provision because she believes that that has led to distorted practice on the ground. Now, our argument is that if the practice is wrong, change the practice guidelines. But the legislation is the biggest guide we have to inform practice. And if the legislation purposely omits priority around kinship care, which I have to add is not just a New Zealand principle as much as that we've grasped it, it is internationally recognised and evidence-based because it reduces trauma on children. It reduces harm done to children. It is child-centred practice. And the fact that it is being explicitly and purposefully removed from this legislation is something we cannot support. Now look, if the Minister has said to us we want greater priority placed on what the child wants, no problem. Let's put the child's view front and centre. If they say, no, I don't want to be placed with family, I do not feel safe, that should be front and centre, no question. Sibling placement, absolutely we agree that being placed with your siblings is of huge importance. That's a connection that we should be retaining as a priority. Let's put that as a principle, front and centre. But let's also maintain the importance of that kinship care. And for Māori, yes, but for non-Māori, for Pacifica, for all kids in care. And if it is not possible, then of course you look more widely. That is what the legislation in 1989 should have achieved. The problem that we had was that in practice, child, youth and family, yes, treated as a priority, but they did not treat it the same as wider care. They did not undertake the same risk analysis and risk assessments. In fact, in many ways, you could assume that it was seen as a less risky option to the state to place in family care because then we were no care and no responsibility. We didn't support those placements in nearly the same way as we've supported every other form of placement. So we don't do proper risk assessment and we don't properly support whānau and family and kinship care. And then when things go wrong, we stand back and say, oh, well, kinship care is broken. That is not true. What this legislation should have done was put kinship care on equal footing with other forms of care in terms of support, but actually lifted the priority of it, retained the priority. I want to highlight again, no one has said that that should happen over and above safety for the child, or over and above a child's view on what they want. But to remove it altogether is plain wrong. It takes us a massive step backwards from where we were as a world-leading nation on child protection issues. And that is a bottom line for us. Mr. Chair, I have to say, there are other provisions around prevention that we support. There are provisions around youth justice and raising the age of the youth court jurisdiction that we support. But we cannot support a bill that makes such a fundamentally wrong move on kinship care. So we in Select Committee are choosing, we will be absolutely as pragmatic and helpful as we can to have those provisions returned. We will work alongside our fellow members, but right now we will not support this bill at this reading until those provisions are returned to this bill. I want to finish on a final point, Mr. Speaker, and my colleagues will talk about the lack of consultation with iwi leaders in particular, and the Māori Women's Welfare League case before the Waitangi Tribunal. I want to finish on one final point. How can you truly take a preventative approach if we do not factor in child poverty and financial stability and the economic conditions that children are growing up in? It is the #1 determinant of child wellbeing. And yet a bill that purports to deal with child wellbeing is not allowing the ministry to take into account any issues around child poverty. A Ministry for Children under Labour will have a plan to eradicate child poverty. That is what our Ministry for Children will do. Oranga Tamariki, Ministry for Children, will care about the well-being of all children, and that means the financial security of their whānau.